friends, welcome back to another topic. So today in this video we are going to share with you the rare 9 judges benches which is usually pass their decision in the cases. So for that purpose you have to see this video, and at the very end of this video you will get to know the various prominent cases in which the rare 9 judges bench as well as the historical 13 judges bench were concluded. So friends, if you are new viewer on my channel and you have not subscribed channel yet, please do subscribe so that you will get all the upcoming updates on law topics at the very time as soon as it is uploaded on this channel, Study Law with SK. So let's start this topic and see what are the various reasons and the rare 9 judges bench of the prominent cases. So firstly, the rare 9 judges bench. It is rare to see the 9 judges bench. Even in its 70-year history, the Supreme Court has only authored 17 9 judges bench judgments. You know, Article 145 bracket में 3 of the Constitution of India does empower the court to form benches comprising more than 5 judges. All these cases involved constitutional issues, and a majority of them revolve around fundamental rights claim, and for that purpose it is also known as the constitutional bench in the Supreme Court. It is a very rare of rarest cases. So if we see the various important cases like you are watching on the screen, the first one is the Sabrimala Puttuswamy case, SR Bommai case, Indira Sahani case, Naresh Sridhar Mirjakar, Supreme Court Advocates on Records Association versus Union of India. So these are the mainly list of cases which are very important to know for everyone if you are pursuing for any judiciary or exams. So basically, if we talk about the first of all important cases is Justice K.S. Puttuswamy retired versus Union of India. The bench unanimously held that right to privacy is a fundamental right protected under the Article 14, 19 and 21 of the Constitution of India. Further reactions in this matter were, first one is decriminalization of homosexuality, that was held in the Navtej Singh Johar versus Union of India, and the second one is abolishing the provisions on crime of adultery, Joseph Sain versus Union of India. The following are the judges sitting in this matter you are watching on the screen. So if we see the second case is of Indira Sahani versus Union of India, which is passed a judgment in the year 1992. The main highlights of the cases you are watching on the screen is the concept of a creamy layer was laid down, and it was directed that such a creamy layer be excluded while identifying backward classes. Second is reservation shall not exceed 50%, and moreover the reservation promotions shall not be allowed. Basically, backward classes under Article 16 bracket 4 cannot be identified on the basis of economic criteria, but the caste system also needs to be considered. Any new disputes regarding criteria were to be raised in the Supreme Court only. So these were the main highlights of the case which were passed in the judgment of the cases Indira Sahani versus Union of India in the year 1992. Next one is SR Bommai versus Union of India, which passed a judgment in the year 1994. The Bommai verdict spelled out clearly that the imposition of Article 356 by the President on a state government should not be arbitrary, and there should be a solid ground for it. This judgment largely helped put an end to the arbitrary impositions seen until then. The following are the sitting judges in this matter like Kuldeep Singh, P.V. Sawant, Kathikala Ramaswamy, S.C. Agarwal, Yogeshwar Daya, B.P. Jeevan Reddy, S.R. Pandian and A.M. Ahmadi, and the last is J.S. Verma. These are the sitting judges in this matter, which is rarely known as the 9 judges bench. The very main important cases of Sabrimala case, which is generally passed their judgment in the year 2006. Indian Young Lawyers Association and others versus the state of Kerala and others. Title of the case: Sabrimala temple devoted to Lord Yeyappa is a temple of great antiquity. In this temple, the entry of women was restricted due to the religious beliefs of the local community. However, on September 28, 2018, the Supreme Court passed a verdict that finally allowed entry of women in Sabrimala temple. The sitting judges in this matter is of Deepak Misra, A.N. Khanvilkar, Rohinton Nariman, Indu Malhotra, D.Y. Chandrachud Reddy, S.N. Dwivedi and Y.V. Chandrachud are the main sitting judges in this matter who passed their verdict and decision on this matter and allowed the entry of women in the Sabrimala temple, which was a very constitutional disputes for the several years. This is just an image of Sabrimala temple. Like if we see three judges case, so the first judges case is held in the year 1981, and in this case a seven judges bench of Supreme Court was formed, and it was held that the opinion of the CGI is not binding in matters related to the appointment of the judges. Second is the second judge's case is known as in the year 1993, which is in a nine judges bench verdicts. Supreme Court introduced the collegium system and added that it was not the CGI's individual opinion but an institutional opinion formed in consultation with the two senior most judges in the Supreme Court. Judge's case is held in the year 1998, and in another remarkable nine judges bench verdict, Supreme Court on President's reference expanded the collegium to a five-member body which comprised generally the CGI, Chief Justice of India, and four of his senior most colleagues. So the last important case is of the historical 13 judges benches, which is very important to know for every legal citizens being a citizen of India and for every law judicial applicant. And this is the case of Keswaran Bharati versus State of Kerala. It is also known as the Keswaran Bharati judgment or the fundamental rights case, which is a landmark decision of the Supreme Court of India where the largest ever 13 judges bench was formed that outlined the basic structure doctrine of the Indian Constitution. The court in this matter asserted its right to strike down amendments to the Constitution that were in violation of the fundamental architecture of the Constitution. So these were the judges of the Supreme Court, which you are watching on the screen, like Sikri, CJ, A.N. Grover, A.N. Rai, D.G. Palekar, H.R. Khanna, J.M. Shelat, K.K. Matthew, K.S. Hegde, M.H. Vag, P. Jagmohan Reddy, S.N. Dwivedi, and Y.V. Chandrachud. And these are the most important judges which passed their decision in the case of Keswaran Bharati versus State of Kerala. This is a very short video which I have shared with you with the topic of the rarest 9 judges bench, and as well as we have seen in this video the rarest of 13 judges bench which was held in the case of Keswaran Bharati versus State of Kerala, which is very important to know, as we everyone know that this is also known as the fundamental rights case, and which usually created a history in the law which is usually governed with the help of Indian Constitution, while the problem arises regarding the drafting or amendment of the fundamental rights in the Indian Constitution, whether it can be amended or not. It's a matter of right, and basically the cases are the following deal in this is of Keswaran Bharati versus State of Kerala. So friends, if you find this video is informative in any matter whatsoever, please don't forget to subscribe our channel, and you have any query with respect to the present video or any other videos uploaded on this channel, do subscribe, comment in the comment box. Your answer will be given as soon as possible. Thanks for watching this topic and see you soon as possible.